what the bone of contention was. The bone of contention wasn't terrorism or treason, but agitation for a separate state. And there's a proviso in that. If you treat us well, we're happy to be Nigerians. That's what he's saying. He has always said that. He has always made it clear that Biafra is not absolute, it's a means to an end. If you don't treat us well, equally, as Nigerians, then you let us go and have a separate state. That's what NNAMDI KANU was saying.
For NNAMDI KANU on this matter, how did you navigate all the booby traps, the landmines, everything to the point when you step out or step down as the lead counsel?
My stint as lead counsel was very fulfilling. I cannot complain. I am trained to handle cases, even when the cases are this tough, such as the case of NNAMDI KANU. You will recall that I assumed the role of lead counsel in February of 2024. And the first step I took when that happened was to file for restoration of his bail. I had anchored this application on what the Supreme Court had said when they remitted this case back to the High Court. The Supreme Court has said it plump and plain, clearly in a concurring judgment, that the revocation of his bail was unfair and it shouldn't have happened, and that the revocation smacked of suspicion of partiality on the part of the High Court that revoked it. And the Supreme Court also cited with approval the judgment I had obtained in January of 2022 from the High Court of Abia State, which condemned the invasion of NNAMDI KANU's house in September 2017 and awarded him 1 billion naira. And the High Court had blamed that invasion for being the sole reason NNAMDI KANU had to leave Nigeria and failed to appear at his trial. So the Supreme Court blamed the government squarely, totally and absolutely, for what the government termed jumping of bail on the part of NNAMDI KANU. So the Supreme Court said basically that he didn't jump bail. So for those reasons, a High Court should have taken the sound decision of revoking his bail. So, and I proceeded to file, but it was denied. And then I appealed the denial to the Court of Appeal. The second step I took to test whether the field of play was going to be fair was to challenge the jurisdiction of the court to subject him to trial. There were judicial issues inherent in his case. Number one was that the charge sheet or the offenses he was alleged to have committed stemmed from broadcasts he made from a foreign soil. That foreign soil was not named, but the laws of Nigeria required that the location of the act leading to the offense be named if it occurred overseas. If it occurred abroad or in a foreign land, that is the only way jurisdiction can be conferred on the Federal High Court, because a determination has to be made first whether that very act or broadcast considered an offense where it occurred. So we know that NNAMDI KANU was between Britain and Kenya on the dates specified on the charge sheet, which were between 2018 and 2021. He was either in Kenya or in Britain. And then you are going to say that you, NNAMDI KANU, made a broadcast that led to an offense in Nigeria, and he didn't indicate where he made the broadcast, and it wasn't in Nigeria. But the laws of Nigeria, in particular, the Terrorism Prevention and Prohibition Act, Section 76, sub 1D3, required that before the Federal High Court can assert jurisdiction over a terrorism-related offense that emanated from a foreign soil, that country has to be named so that it will be determined whether that conduct is also considered a crime there. It didn't happen in this case. So on that basis and on the basis of other secondary factors and issues, I and my team, my able team, we raised an objection to the jurisdiction, to the authority of the court to subject him to trial. But that objection was denied in September, I think either August or September of 2024, whereupon we proceeded to the Court of Appeal to determine the question. And then from there, things began to unravel, to recusal of the judge, reassignment of the case, and so on and so forth to the new judge, all the way to March 2025, when I stepped down as lead counsel and handed over the mantle to Chief Kanu.
Looking at the obvious from what you said now, you tried to test the waters, and of course you saw that undoubtedly the waters were definitely not going to be fair. So did it affect your confidence in the judiciary still going ahead with the case?
Well, as a lawyer, if I lose confidence in the judiciary, I had better hang my shingles and my boots and whatever and go to the village and resort to farming and, they face Omuna meetings and so on and so forth. I still have confidence in the judiciary. I live in this country. I apply the trade of a legal practitioner. I practice law. So when I take cases to court, I take those cases to court with full confidence that I'm stepping into the halls of justice and justice shall be done. My problem was with the prosecution, the pace, the attrition, the muscular approach, the aggression that was fueling that prosecution can overwhelm any system, any judicial system. You can take example of President Trump. You remember he was subjected to aggressive prosecution in New York. And they convicted him, I think, for 34 counts of criminal offenses, but he proceeded to become president of the United States. So the judiciary in New York was as overwhelmed as I believe the judiciary in Nigeria was overwhelmed regarding NNAMDI Kanu's case. So that was why my push against that very process was directed mostly towards the prosecution, rather than the judiciary that was sitting there and the case was thrown into their lap. And like I said in a previous interview, the judiciary is not infallible. It can make mistakes. Take example of some election petitions. We have had decisions emanating from the judiciary from election petitions that roiled this system, that convulsed Nigeria, that Nigerians believed that we are patently unfair. So judiciary can make errors. So I'm very reluctant in attributing any mischief to judiciary. As a lawyer, I'm an officer in the Temple of Justice. It's my duty to protect the system that I expect to give justice to me and to other Nigerians. But it's also my duty to criticize the system when it goes wrong. And in this case of NNAMDI Kanu, both the conviction and the sentencing were clearly wrong. And I will stand to say it any day. It was an error of law and error of fact.
Let's look at, you made reference to the judgments he got from Umuahia High Court, 1 billion naira.
Yeah.
All these cases where he got judgments and even the cost, has any effort been made to pay it?
Well, none of these judgments, has been obeyed by the federal government. I have 3 judgments in my kiri. The one of Umuahia that you mentioned for 1 billion. I got one also from the Federal High Court for 500 million.
Federal High Court Abuja.
Umuahia, that condemned his rendition and ordered that he be returned to Kenya. If he was returned to Kenya, this trial or prosecution wouldn't have happened. The federal government disobeyed all of that. I got one from the Enugu State High Court that condemned the proscription of IPOB and awarded 8 billion naira to NNAMDI Kanu. That judgment was never implemented to this day. The implementation could have been less towards the monetary aspect and more towards deproscribing IPOB. 3 or 4 or even 5 of the charges alleged against NNAMDI Kanu were all based on the proscription of IPOB. So if IPOB was deproscribed and redesignated as a non-terrorist group, NNAMDI Kanu wouldn't have faced prosecution for those alleged offenses. So I wasn't really more into the monetary aspect of these judgments. I was more into the policy expressed in those judgments, that if the federal government had obeyed a single one, particularly the one from the Federal High Court, NNAMDI KANU would not be in Nigeria today. He would be in Kenya fighting extradition request from Nigeria, which was what they were supposed to do in the first place. But they didn't. So it goes back to that extraordinary rendition, which is a remarkable legal defense for him, but which the Supreme Court unfortunately and erroneously rejected as a barrier to his prosecution. I still stand by my proposition, of which I was the first to step out in July, as far back as 7th July 2021. Check it out. That was 8 days after NNAMDI KANU was brought into Nigeria, and everybody was saying he was extradited. I came forward and I said, no, this is not extradition, it's extraordinary rendition. And the government has triggered a honestness of judicial and prosecutorial challenges to its power to bring NNAMDI KANU to trial by the dint of this criminal conduct by the state. It's a criminal conduct by the state. So that the Federal High Court came down with a gavel and confirmed it and ordered you to pay 500 million. Well, maybe you can tarry a while about the 500 million and put me to the pain of garnishment or garnishing proceedings. But what about the order? The part of the order directing you to restore him to the status quo by returning him to Kenya, and he ignored that. He did not pay any attention, and he continued with the prosecution. That was why I even took the extra step of going on a public protest, which was directed against the presidency, against the prosecution, not against the court. You get it clear? That has to be made clear. I had problem with prosecuting NNAMDI KANU from the beginning. Check it out, Google it, from 2021. I didn't believe that he was subject to prosecution. I do believe that NNAMDI KANU is a victim of manifest, tremendous prosecutorial misconduct that started with his rendition or his kidnapping on June 19 on Kenyan soil, and his forcible rendition or transfer to Nigeria on 27th June 2021. So all these factors combined convinced me that the state had no valid case against him. And that was what guided my approach to this case from even when I was lead counsel. And what I feared happened on 20th November 2025.
How do we reconcile the fact that despite the Supreme Court observations, despite the Supreme Court overt comments on some of these issues, the state still went ahead, and even the judges themselves, given some of these things you pointed out, a case of, is it the clipper not being sharp or the barber not being good enough?
Well, it's very baffling, Victor. It's very, very troubling. I would refer you back to the case of Awolowo, 1963. His prosecution too by the state, by the Tafawa Balewa, or what people called northern-led federal government, was also very attritional. He was accused to have committed treason and treasonable felony. Tell me, as a civilian, how possible it is for a civilian to overthrow a government. It has never happened anywhere. But Awolowo was accused and tried for attempt to overthrow the federal government, and he was convicted for that. And later on, when the judge, late Justice Show, a very capable judge of high integrity, wrote his memoirs, he confessed that in rendering that judgment, convicting Awolowo, yes, in rendering that judgment, convicting him and sentencing him, he felt that his hands were tied. What does that tell you? It tells you that the case was bigger than him. There are cases that can be bigger than judiciary. Cases that border on national security and high political content. are better handled politically, such as that of Nelson Mandela as well. In the end, it proved bigger than the South African judiciary. It was resolved politically.
So can we say NNAMDI Kanu's case falls under one of those cases that is bigger than the judiciary?
Yes, NNAMDI Kanu's case was bigger than the judiciary. I said it from the get-go. If you gave it to the judiciary to handle it, to resolve it, it was prone to make error or make mistakes, because the overbearing weight of the state was too much to the point that it could tilt the scale of justice in the wrong way. The judiciary is not immune from a lot of things that you and I are also not immune from. So from the get-go, I was afraid that this matter was inappropriate to be resolved by the judiciary, that if you gave it to the judiciary to resolve, it could make a monumental error, and it happened. So cases like that of Mandela, and of course also he had that of Enahoro, he was also released from prison. He didn't serve his term. Mahatma Gandhi was convicted at some point in South Africa. He didn't serve his term. He learned to, the case eventually went to political resolution, even in India. Martin Luther King, United States, the same thing. It was resolved by the White House. And in fact, it was Martin Luther King's legal problems in the southern part of the United States relating to Jim Crow laws and segregation that led to the promulgation or enactment of the Civil Rights Act in 1964. So eventually, the issue of segregation, discrimination, Jim Crow laws, and all those ills that were plaguing American society in the late 50s and early 60s were not resolved by the judiciary, but by the executive branch through a political process.
Looking at your role as lead counsel at the time you did, by hindsight, is there anything you think you would have done differently?
No. I'm proud of my stint. I'm proud of my team that worked with me at the time. We kept the faith, and we tried to block the trial. When I use the word block, yes, I'm proud to use the word, because the first duty of a criminal defense counsel is to block a trial in which he believes the High Court has no jurisdiction, or to prevent it, if you want to use that word, or at least to put the court to the first task of determining its jurisdiction before it goes to trial. Assuming the case stayed that way, you wouldn't have had a retrial. Justice Binta Moritara Nyeko, in fairness to her, was ready to give us adjournment sine die to allow time for the Koroape to determine whether she had jurisdiction or not. She said it in open court herself. So if what we were doing had continued and there was no change of baton, there wouldn't have been a trial. If there was no trial, there wouldn't have been any conviction and sentencing. But that is not to say that the council that took over and took the case to trial made a mistake. No, they didn't. They have a different strategy. They felt that the case had no merit to begin with. And I agree with them, because I was also a member of the team, a junior member, but a member anyway. I agree with them that the case had no merit. That was why I said at an interview that your words alone, spoken in Kenya, your words alone, spoken in Kenya or Britain, cannot be a basis for convicting you for things that occurred in Nigeria, and in which case nobody came forward to the court to say it is your words, those words you spoke in Kenya or Britain, that made me to kill someone in Nigeria. There was no such evidence before the court. So based on that, the senior lawyers that led our team from February or March 2025 believed that this case had no merit. And that was why they put it to the test of a full-blown trial.
Let's look at Igbo leaders, how are they rallying around Kanu? Have they abandoned him?
No, no, Igbos will never abandon NNAMDI KANU. NNAMDI KANU for now is the big elephant in the room as far as the Igbo are concerned. They haven't. They have rallied. He has had a lot of august visitors. There's an archbishop or a bishop from Igbo land who visited him. The governor of Abia State, I commend him very strongly for visiting him, Lex Oti, His Excellency. He did the right thing by visiting him, showing fraternity. It's very gutsy, very courageous step for him to have taken. Honorable Biagocha, a ranking member of the Federal House of Representatives, also has visited NNAMDI KANU, and so on and so forth. So, and I have a hunch that a lot more prominent Igbo persons will be visiting him. But also, let me use this opportunity to commend the Igbo youths and the Igbo in general for taking this thing well. You know, I had this fear that it may have led to an unrest. When Awolowo was convicted in the 60s, it led to Operation Wetie in western Nigeria. Houses were burnt, people were killed, the West was on fire. So that Igbo land restrained itself is something to be commended. And that restraint is going to parlay, is going to, I think, make us all to have a very good Christmas this year, free of insecurity and everything. And I join my voice to the voices of the Igbos who have called on the Igbo to continue to be restrained, to maintain the peace and order so that Igbo land would have a taste of security like it used to do before. So, NNAMDI KANU is our favorite son. Ndị Igbo will never abandon him. They don't. Igbos don't abandon their own in a foreign land or their own who is in distress. So Igbos are standing by him. I know that. I'm involved. I get phone calls, text messages, and everything has always been about expression of solidarity and fraternity with him. It happened to all of us. It's not only to him.
Do you think his movement to Sokoto was to limit the constant flow of people, or if you like, support for him?
That may have been. That may have been, but I'm not going to speculate. But I do believe that the practical implication or the practical consequence of that is what you have said. It has limited. I know one of my colleagues, Barrister Patrick Agazie, and the other one, Barrister Judu Wanye, they've been attempting to travel to Sokoto to see him for the past 1 week. They couldn't get a flight. Barrister Patrick came from and we had to return. Barrister Jude is in Abuja here, so he left this morning. It was only today he got a flight. So the consequence of that has been that it has reduced the access to him of people that normally would have had easier access to him if he were in the vicinity of Abuja.
We've heard so much talks about political solution, and you've alluded to the fact that when you have cases that are bigger than the judiciary, with the examples that you've cited within and outside Nigeria, we tend to look at political solution. How soon are we expecting this to happen?
Well, in the end, it has to happen, and it has to happen soon, because there's a limit to how something like this should drag on. I don't see anything that Nigerian government would benefit from keeping NNAMDI KANU in detention for the long haul. Peace and reconciliation need to return to the land. And the very first step, and in fact the most effective step the government can take in doing that, the federal government, is to have him released as soon as possible.
All right. Some persons are of the opinion that given what the government has subjected Kanu to, the government should apologize to him and release him unconditionally.
Okay, well, Victor, this is a very good question. Let me begin with that judgment of Abia State High Court that I referred to previously, that was delivered on 22nd January 2022. Now, in that judgment, the judge, in addition to ordering the federal government to pay 1 billion, ordered the federal government to apologize to Mazi Nnamdi Kanu for invading his home in 2017. The apology never came. What came was more prosecutions. What came was more amendments of charges that now graduated them from treasonable felony and treason to incitement of terror. Do you understand? So they never apologized. That judgment also directed the federal government to pursue political solution. A lot of people don't know this, but I had done an interview previously where I called the attention of the federal government to that and the Nigerian public. It was never implemented. Okay? Then the one from the Federal High Court, Umaya, also ordered the federal government to apologize to him. The federal government never did. Now this has occurred. The conviction has occurred. Well, the government might feel that it will be a very strange act of governance to apologize to somebody that a court convicted. That is how the government will feel. But the best way the government can feel sorry or can have a rethink about this matter is to consider the Mazi Nnamdi Kanu, consider him for an early release from prison. You don't have to mount it. Sometimes the best sorry is not saying sorry, but it lies in your conduct. That's how I'm going to answer.
So you expect a speedy release or a speedy resolution of this problem politically?
Well, there is no problem really. The problem is that of injustice to a certain set of people. Mazi Nnamdi Kanu was fighting against injustice being levied against him. You know, he took the high road in 2015 when Buhari came to power. People seem to have lost sight of what the bone of contention was. The bone of contention wasn't terrorism or treason, but agitation for a separate state. And there's a proviso in that. If you treat us well, we're happy to be Nigerians. That's what he's saying. He has always said that. He has always made it clear that Biafra is not absolute. It's a means to an end. If you don't treat us well, equally, as Nigerians, then you let us go and have a separate state. That's what Mazi Nnamdi Kanu was saying. What is wrong in that? It's called self-determination. Do you understand? That you now turned it to something that had impact from terrorism impact is something that baffles every reasonable mind. So the bone of contention is agitation for justice, political justice. That's all. So if we can pedal back and go to the basics and ask ourselves as a society, as a government, what really is the matter? The matter is justice for all. So why don't you engage in dialogue and have a common ground where you can, a point where you can get to say, yes, we agree, this is how the federation should proceed from now on, so that every part of the federation gets a fair shake. That is all. If you do that, I don't think there will be anybody that would resort to dissent or disagreement or agitation or protest or whatever. People will have a tendency of being happy, and they will channel their grievances through the political process or the institutions we have, like the assemblies, the judiciary, and the executive branch. Nobody will go outside of that. But when you have someone on a political chokehold, and you're not letting go, the reaction of that person, the only reaction open, might just be a resort to agitation for a separate state.